Hello, good afternoon, everyone, and welcome. I'm Mary Kappa, commercial business broker with McBride Kenyon Associates and president of the French American Business Council of West Florida, known as FRAMCO. Thank you all for joining us today for this exclusive webinar on commercial real estate, understanding leases and assignments. This is a critical topic for business owners, investors, and especially for those navigating the US market, including many international and E2 visa investors we work with. I'm very pleased to welcome today's speaker, Felix Montanez from Montanez Law Firm, who specializes in business and commercial real estate law. Felix works closely with entrepreneurs and investors to structure and protect their deals, so we are in great hands today. So let me tell you a little bit about Felix Montanez, a little bit with bio. So Felix Montanez is a board certified real estate attorney and the founder of Montanez Law Firm, PA, a Tampa-based law firm focused on real estate and business transactions. He also owns Rocket Title Services, a title company handling residential and commercial closings throughout Florida. Felix regularly represents buyers, sellers, investors, landlords, and tenants in commercial real estate matters, including acquisitions, commercial leases, lease assignments, and transactions involving the sale of businesses tied to real estate, to property. He practices throughout Florida with a primary focus on the Tampa Bay area. Well, Felix, thank you for being with us. Let's dive right in.
Perfect. Thank you very much. I appreciate your time and I appreciate the French American Business Council for having me. I'm excited to be here because this is a topic where I really think people can set themselves up for success or they can make very expensive mistakes. So I'm going to try to be practical today, and it's not going to be a law school lecture or anything like that, but just a little tidbit, just so you know enough. It's important to know what you don't know, and so know enough to seek help if you need it, and just avoid expensive mistakes when it comes to commercial leases, either transferring the leases, buying into a new business, entering into a new lease, and things like that. So I'll get started. I'll tell you a little bit more about me. I think Betty covered some of it. Yeah, so I'm a board certified real estate attorney. We practice primarily real estate law. I'm the owner of Montanez Law Firm. That's a firm. It's four attorneys total currently. I grew up in Orlando. I got my bachelor's degree from the University of Central Florida, UCF. Go Knights. After that, I got my law degree from Ave Maria School of Law in Naples. After that, I graduated fourth in my class there. So I did pretty good in law school. And then I should say pretty well in law school. And then I went to get my LLM in taxation. So I'm a master's in law from the University of Florida. Go Gators. And then ever since then, I've been practicing real estate law here in Tampa Bay. We do both real estate transactions and litigation. Today, we'll be primarily focusing on a transactional part of the job, which is real estate, which would be commercial leases. We try to avoid those ending up in litigation, but sometimes they do. So we do that as well. And yeah, but I've been doing this. It's going to be 13 years. So our law firm, I started off with another firm and eventually opened my own. Our law firm turned 10 last year, so it's turning 11 this year. Um, so yeah, so the topics, here's the things I'm basically going to cover today. So I'm going to talk about commercial leases generally, how they compare to residential leases, which most people are more familiar with, and what are the key clauses to those commercial leases. I'm going to talk about assigning leases to other people and what the transfer strategies come with that. I'm going to talk about protecting yourself before signing a commercial lease. And lastly, I'm going to touch about the E2 visa process. I'm not an immigration attorney, so I'm not an expert in immigration per se, but there's some ways where the E2 visa process interacts with this type of law. And since we're part of Framco, we're here for Framco, I thought it'd be important to point out where that
Yeah.
intersects and what you could do to kind of protect yourself. Um, so yeah, jumping right in. What's the difference between commercial and residential leases? I think most people are more familiar with residential leases. In residential leases, the government provides a baseline of what the landlord has to provide. The landlord cannot, they don't allow slumlords, for example. So there's a minimum standard that the property must meet in order for it to be rented at all. There's certain maintenance requirements that the landlord cannot waive, and things like that. There's extra protections for the consumer. None of that exists in commercial leases, and everything is negotiable. Um, so that's important to know. So tenants they're signing these leases. They're sometimes they assume the landlord is gonna provide basic upkeep, that they're gonna provide the shell of the property, they're gonna maintain the roof. That's not necessarily the case. The lease says what the lease says. There's not a lot of protections in that regard. So it's important to read the lease and these leases. And I prepare. I mean, I represent landlords and I represent tenants. So I know these leases. When I prepare them, they can be 30, 40, 50 pages long. And the other way, and generally they're designed to protect the landlord. That's kind of the nature of the game. So as a tenant coming in trying to invest, it's important to be aware of that and really take time to read over the contract and understand everything that happens in that regard. And so commercial leases, an additional thing I wanted to point out is that everything is as is. So there's no if you want to rent a building that's falling apart and it's not functional, if you sign on the contract, that's generally what you're going to get. Unless the contract requires a landlord to make improvements, they're not required by law or anything like that to make improvements. If you sign a bad lease, you're stuck with the bad lease. Commercial leases are not about fairness. It's all about risk allocation. Who's responsible for what, and everything is negotiable. So yeah, so we can so next I wanted to talk about the common types of commercial leases. There's something commonly called a triple net lease. Triple net. That means the landlord, all of the landlord's expenses are paid for by the tenant. So the landlord, if the rent is $5,000 a month, the landlord will pocket $5,000 per month. All the landlord's expenses are generally covered by the tenant. So the tenant has to pay the rent. In my example, the $5,000. They also have to pay um, the landlord's operating expenses, and I'll get to what can constitute operating expenses. They can pay the property taxes, they can pay insurance, and like I said, all this is negotiable, but it's these are the broad categories of the types of leases. So in the triple net lease, the tenant pays for everything. They pay for property taxes, insurance. Those are the two biggest one. Depending on what the lease says and how it defines operating expenses, they could even be responsible for paying the salaries of the landlord's employees, and things like that. Oftentimes, if it's a commercial building, if there's 200 tenants, then those costs are split among all the tenants. But it could potentially be on a one-to-one basis as well. So that was triple net. So the next type is the other extreme, which is a gross full service lease. That's a lease where the tenant pays rent, and that includes everything. It includes property taxes, it includes insurance. It's more similar to what you would expect in a residential lease. The landlord pays their expenses, and the tenant just pays rent. And then modified gross is the next type of lease, and that's kind of somewhere in between triple net and gross. Sometimes it's oftentimes during the negotiation process, the landlord will say, "I'll pay for X, Y, Z, but I won't pay for ABC." And that's all kind of negotiable. And then it becomes modified gross, which is something in between. And then so these operating expenses in a triple net lease, they can get really kind of out of hand, and it can really be a big risk. It can be a big risk for both sides. So if the tenant is responsible for all the operating expenses, then if there's any big increase in property taxes and insurance, we've had insurance issues here in Florida. If there's any big increase, then the tenant's on the hook for them. So sometimes they'll negotiate what's called an expense stop. And what an expense stop says is that the tenant is responsible for costs up to a certain amount. Sometimes it's done per square foot. The tenant is responsible for $3 per square foot in operating expenses for that year, but it cannot go over that. So that's one way I see where it's often modified to kind of share the risk. Sometimes in a full service lease, the landlord will say, "I will cover operating expenses based on a base year." For example, if the lease is being signed now, they might say, "I will cover all the operating expenses as they were in 2025." If the operating expenses exceed what it was in 2025, then the tenant would be responsible for their share of that. So that's common as well. Um, so going
So,
back to operating expenses,
yeah.
yeah, so operating expenses are a big part of the negotiation in a commercial lease. CAM stands for common area maintenance. That means common area shared by all the tenants. The common area maintenance is generally something that's included in operating expenses that the tenant could be responsible for. Generally, the standard practice is that the tenant will pay an estimated amount of operating expenses every month. And then once a year, the landlord will go back and reconcile with like, well, the operating expense is higher or low. And if they were higher, then the tenant has to make up the difference. If they're lower, then most of the time the tenant will get their money back or will be applied to a future year or something like that. So, yeah. So, like I said, everything in a commercial lease is very negotiable. So that's a lot of times that's kind of where we're negotiating. Like who's responsible for what. Um, I wanted to illustrate what operating expenses are. This is one paragraph of the leases we use. This is size 8 font, and you can see it takes up the whole thing. This is not the entire operating expense section. This is just the one paragraph that defines what operating expenses are. So just out of illustration, I bolded something so it could include costs of management, operation, repair, and maintenance of the building. It could include wages, salary, professional fees, taxes, insurance, and benefits, and other payroll burdens of the employees of the landlord's employees. It could include a building management fee, maintenance, security personnel, equipment. Like a lot of things, tenants sometimes wouldn't think like, well, they're just thinking property taxes and insurance. They're not thinking all of the other things. But the landlords, and like I said, most of these leases are designed to protect the landlord. So they'll put in all these options. And one additional thing I think that surprised a lot of people, capital improvements. If the landlord wants to invest in the building and make it better, then the tenant could be responsible for preparing their share of those capital improvements, amortized over a point of time. So this is just the definition of operating expenses. That's what this one paragraph is. But it is just to illustrate that there's a lot that goes into it, and all these things are negotiable. If you don't read it and you don't negotiate it, then you're going to get stuck with whatever the landlord decides. Um, um, so okay. I'll move on to the next slide. So yeah, so oftentimes, and this varies from commercial building to commercial building. Sometimes the spaces are what I'd say turnkey. They're already ready to be used. The tenant gets the lease on day one, and on day 2 or 3, they can start operating. It's already ready to go. That's probably more common for offices and things like that. But other types of businesses, like a restaurant or
Restaurant. Mhm.
warehouse or something like that, then the tenant's going to have to go in and they're going to have to improve the space to make it ready to operate their business. So that creates a lot of issues from a commercial lease standpoint. One thing, these commercial leases, they can be short or they can be long. They can be really long. Oftentimes we have 5-year terms with, 3 or 4 renewal periods where the tenant has the option to renew for 5 additional years each time. So it could be a 30-year lease. The reason that's important because the tenant might put a couple $100,000 into the space just to make it ready to operate. They cannot afford for the landlord to, 2, 3 years later say, "Oh, I don't want to renew the lease." Like they're already heavily invested into the space, so the length of the term is really important. And then one thing to negotiate is oftentimes the landlords will offer what's called a tenant improvement allowance. So the landlord will pay for some of the improvements to the space. Like I said, there's no standard, so everything is negotiable. It kind of depends on the market and how, what the rent is and what the landlord's willing to do. But the landlord will say, okay, and from their point of view, it's like, okay, you're going to improve my building. It's going to make it better. So even if you leave, I'm going to benefit from those improvements. So I'm willing to pay for some of it. So I'll do a tenant improvement allowance. Sometimes the landlord will just give the tenant the money, usually through contractors and things like that, directly to make the improvements. At other times, it'll be credited against rent for a certain amount of time. So that's one thing. That's an additional negotiating area that's common. The tenant improvement allowance. Sometimes also the the parties will negotiate for rent abatement. There's a certain amount of time where the tenant will not have to pay rent. That's basically to get up and started, and that could be 18 months. It could be 12 months. Could be 2 months. Could be 3 months. So maybe the landlord won't agree to a tenant improvement allowance, but they'll say, okay, I know you're going to have to improve the place, and you're not even going to be making money for some time. So you won't have to pay rent for 6 months, for example. So those are all things that you can negotiate. Sometimes the parties can negotiate that the landlord will do certain work, that the landlord will prepare the space for rental instead of the tenant. That's something that could be negotiated as well. So those things that commonly come up during the lease negotiation process. Um, so yeah, so the next area I wanted to touch on is maintenance and repairs. And I sound like a broken record, but again, this is all negotiable. So oftentimes in a triple net lease, the tenant will be responsible for all the maintenance. One big area of negotiation in Florida is air conditioning. Who's going to take care of the HVAC unit? They're expensive, they're necessary, and they break. So who's responsible for HVAC? All that is negotiable. My landlords will generally require that the tenant have a HVAC service contract, that they have to pay a professional company to come in and check on the AC and service it continually. Sometimes the landlord will cover. So sometimes the leases will say, oh, the tenant has to cover all maintenance up to $3,000, for example. If it goes over 3,000, then the landlord will take care of it. Some of them say, well, the landlord is only responsible for the shell, for the building itself. The tenant is responsible for everything else. So all those things are important things to negotiate. I've had unfortunate situations where tenants come to me where they rented a place, and unbeknownst to them, the roof was leaking. It was not functional. The roof had to be replaced. They have a 5-year lease, and the contract says that the tenant is responsible for all roof repairs and all maintenance to the roof. That's a difficult situation because generally, whatever the contract says, the contract says. So you really have to be aware of that. And like I said earlier, you generally take these properties in as is condition. So it doesn't matter how good or bad the condition is. If you agree to rent it, you agree to rent it. So it does often make sense. If it's a long lease, an expensive lease, sometimes it's better to treat it as as you would a purchase. Hire an inspector, do all your due diligence because you're locked in for a long time. There's a lot of money at play. So next, I wanted to talk about personal guarantees. So this is so for small businesses, for newer businesses,
Mm.
landlords will almost always require that the owners of the company personally guarantee the contract. If you know if the tenant is I don't know, if the tenant is Publix, then you probably won't require a personal guarantee because it's a huge company, it's been around forever. You don't need that protection. But for most of my clients, for most of the people you'll meet, the landlord will generally require personal guarantees to make sure you just don't shut down the LLC or the corporation and then walk away. So from the tenant perspective, that's important to know because there's no escaping these obligations, absent the tenant themselves filing bankruptcy and things like that. This debt will follow the tenant around. So it's uh, it's important to keep that in mind that generally you will have to sign a personal guarantee if you want a lease from the landlord, unless some landlords are not being advised by an attorney or anything like that, and you can get away with not having one. But for the most part, you're gonna have to um, you're gonna have to do a personal guarantee. Sometimes, and I'll talk about this more in the E2 visa context.
Mhm.
So that can be that can be scary. Well, I'm personally guaranteed on this on this lease for 5, 10, 15 years. Like that, I don't want to do that. Sometimes you can negotiate what's called burn off, where basically you'll guarantee the lease for a certain amount of time, and then after that, it goes away. That's one thing that you can negotiate. Um, so yeah, and then so lease assignments and transfers. That's also something that's highly negotiated. So most leases I come across will say that the if you want to assign the lease or transfer the lease to the tenant selling his business and he wants to transfer the lease to someone else, that's an example. They want to assign the lease. Generally, the landlord has to consent to that assignment. And most leases that I see will say that that consent cannot be unreasonably withheld. And I believe the law basically backs that up. The landlord cannot unreasonably withhold the consent to transfer the lease. But this can really blow up deals. And I know Betty's aware of that. We had one that
We
kind of
had one
happened
here.
like that, where the landlord sometimes will be very unreasonable. They'll see it as an opportunity to make more money. And they're really not supposed to do that. But it's really if it the time to negotiate this is when the lease is entered into. Be clear, what would be what would be an adequate assignment and what wouldn't be an adequate assignment. A lot of times the landlords will allow the lease to be transferred, but they will not release any personal guarantees. So that's something else that has to be considered and negotiated. Some and then a lot of times the landlords will have these profit sharing clauses where like, well, if you're going to assign it, you can't assign it for more money than you're paying me, or I'm entitled to a portion of that profit or all that profit. So if if the lease says the tenant's required to pay $5,000 per month, and then the tenant finds someone else who's willing to rent it for $6,000 per month, the landlords often will not let the tenant pocket that difference. They will either be entitled to all of it or some of it. Sometimes they'll share it because they don't want to, better than getting nothing. That's something to keep in mind. And like I mentioned earlier with the E2 visa, so if for some reason the visa gets rejected, then you want to be able to assign this lease. So that's something that's important to keep in mind and to really review what's required there. And you can create limits on, the it is reasonable say so if the tenant is assigning the contract to someone else and for some reason the landlord feels that this new person is not as credit worthy, then it would make sense for the landlord to increase the amount of the security deposit, for example, but it doesn't necessarily make sense for them to just increase rent. So sometimes the courts would look at that and consider it a money grab. But you don't want to end up in any kind of core litigation and stuff like that. So it's really important to keep it clear from the beginning when you can assign it and when you cannot. So I kind of touched on some of this already. So you have to plan your exit strategy up front. The landlord approval can kill the deal. So that's something to keep in mind. And in the business sale, this comes up a lot in the business sale context. Um, uh, it should be no negotiated. Something came to my mind now that I didn't mention earlier. Maybe I'll mention it now. It's important to, and it kind of bleeds into the next slide. When protecting yourself when you're signing the lease, the term of the lease is very important, even if you're receiving it by assignment. I had a client who purchased a business for $150,000, um, and um, and they didn't seek approval from the landlord. They didn't talk to the landlord, nothing. They just sold the business. He took it over. After taking over the business, the landlord says, "Hey, your lease is expiring in 3 months, and I'm going to do something else with the space. You got to move out. I'm not renewing." My client's like, "Well, I just bought this $150,000 business, and it's tied to that spot. It's not that it was a it was a smoothie shop. So the location really mattered. He couldn't just pick another spot, and it wasn't that easy. And unfortunately, he didn't read the contract. He didn't look at the term of the contract. He assumed the landlord was going to renew. So oftentimes when we're negotiating these assignments, you have to make sure that the renewal term is in place. And I think if you work with a broker like
Yeah.
Betty, they'll advise you of that. My client did it all by themselves. They did not get an attorney to help them. They did not get a commercial broker to help them or business broker to help them. So they kind of missed that, and it cost them a lot of money. So they came to me trying to, oh, what could I do legally? And the answer was really nothing. There's nothing you can do. Your lease expires. They don't have to renew it. Um, you should have negotiated that before you bought the property, and that's the custom way that it would be done. So yeah, in terms of protecting yourself in other ways, so I would say read the CAM provisions and the operating expense. People will use the term CAM and operating expense contribution interchangeably. Technically, they're different. CAM is only for common area maintenance, not other operating expenses. But people will use those terms interchangeably. So that's kind of what I'm doing here. I would read those provisions very carefully. You have to understand the total cost, not just the rent. This is not, you couldn't, unless it's a gross lease where everything's included, most of the time that's not the case. You're going to have to pay some additional expenses. So you have to understand what the true cost is. And then you have to negotiate who's going to do repairs and guarantees. And then I always recommend, not only because I'm in that business, but to get a legal review. With these commercial leases, it's buyer beware. Whatever you sign, you sign. So you have to make sure that you understand that you're very careful with it. And you have to think about what your exit strategy is if you can't stay on the lease. So that bleeds into this. Some of the big mistakes to avoid is focusing only on rent, ignoring operating expenses, not planning an exit strategy, and
Mm.
signing a personal guarantee without understanding what a personal guarantee is. Sometimes the personal guarantee is a lot of times unavoidable. You're going to have to sign one if you want the lease. Most landlords are not going to rent to someone with a brand new business, or unless it's a long established business with great financials. Most of the time they're going to ask for a personal guarantee, but you have to kind of understand the risk, and you have to understand what right you have to assign the contract, and if you assign it, are you released from the liability or not? Oftentimes you would not be. Um, so so next, just touching a little bit on the E2 visa. Like I said earlier, I'm not an immigration attorney. I'm not an expert in the E2 visa process, but I've seen how it interacts with commercial leases, and I worked with immigration attorneys that kind of have those concerns. So generally, for anyone who might not know, E2 visa is generally an investor visa. And so it requires an investment in U.S. business. Generally, the business must be active. So, you can't just buy a bunch of stock. You can't buy buildings to rent. Generally, I think it has to be an active business that could, I think a lot of things that they look at is whether it's going to employ people in America, whether it's going to benefit them. So this is a good program, a popular program that a lot of investors want to use in order to come to the US. So how's that relate to commercial leases? Well, it helps in the immigration process if you can show that you have a lease. That, hey, this is a real business. Here's my lease. I personally guaranteed it. I've got skin in the game. This is actually gonna happen. So oftentimes they won't approve the visa unless you have some kind of lease or some kind of other proof of active operations. So it shows that you're committed to the business and that you have operations that are started or about to start. So it helps. The commercial lease will help you get the visa um, in the first place. But with that comes risk. What if you don't get the visa? You just signed this 5-year lease with personal guarantees. Uh, what if you don't get the visa? So you have to protect against that. So a lot of times we will negotiate um, contingencies. Will basically allow the tenant to get out maybe for a cost if they end up not being guaranteed for the E2 visa. Because sometimes the business might not even get started or may not even profit at all if the E2 visa is never approved. So you kind of want to address that if you're going to the E2 visa contract. You want to address that with the landlord and talk about personal guarantees and things of that nature, and just make sure that like I said, there's an exit strategy in place. Um, so the next slide kind of just touch on some of the things I've already touched upon. Contingency clauses. Sometimes, so generally, like I said earlier, if you're investing a lot in the property, if you're building it out, if you're doing a build out that's very expensive, then generally you want a longer term because you don't want the landlord to be able to say, "Hey, I'm keeping all the improvements. You got to go." Um, but in the context of E2 visas, you may not want to guarantee such a long term. So one strategy people use is that they'll do an initial term that's 1 or 2 years, and then they'll have a tenant option to renew. So the tenant would have the option to renew the lease for another 5, 10, 15 years, whatever the case may be. That's one strategy. Another strategy is to when negotiating the assignment, make sure there's flexibility there, kind of clearly define, what a good assignment partner would be or would not be. And then, like I said, you can negotiate the guarantees where maybe the guarantees lapse upon assignment or after a certain amount of time if the landlord is giving advance notice. So with that, that's kind of all I had for today. I'm happy to answer any questions anyone may have. I appreciate everyone's time again, and you can.
So I have, thank you, Felix. So I have a question. What about, can you talk about the key money? Because last time we were talking about that for lease assignment, and we saw that they had a key money in on the lease. So is that assignable or is that what is it exactly?
So key money, often landlords will refer to as key money. Sometimes that just means like an upfront payment in order from the tenant in order to start the lease. Like, hey, on top of the normal rent, the normal rent that you're paying, I want just at the start, I want an extra 10 grand just to get this started. Just kind of a non just because I mean, like I said, everything's negotiable. That's the landlord wants it. They want key money. They want money for you to move in. They can negotiate that. We had in our scenario, we had an issue where the landlord was asking for quote unquote key money in relation to an assignment.
Mm-hmm.
To me, I don't think that is okay because the assignment's not supposed to be unreasonably withheld. Like I said, it makes sense for the landlord to say, "Oh, this is a risk for me. I'm going to increase your deposit, your security
Yeah.
deposit."
Okay.
But it doesn't make sense for them to ask for key money, which is non-refundable, just pure profit for them as a condition of the assignment. I think if it went to court, a court would likely rule that was not allowed, that was not legitimate. With that being said, who wants to go to court? So oftentimes the landlord could kill the deal even if you don't actually test it, the
Yeah.
litigation. the issue. I mean, it may not be worth it. But
So,
in
so,
that
so,
situation, yeah, I don't think key money should be required as for an assignment.
yeah,
There's other things the landlord can do to mitigate their risk if the new tenant is not as credit worthy. Like I said, it makes sense logically to increase the security deposit. The deposit is refundable in theory, but in that situation, I think it was just a money grab by the
yeah,
landlord. They knew the tenant needed to transfer the property, so
yeah. Okay.
use.
Well, it's good to know anyway. So, and what are the biggest mistakes you see from business owners when they lease space?
So yeah, so from the landlord's perspective, yeah, I'd say when landlords do it on their own, like when they don't have someone advising them or an attorney, anything like that, sometimes they'll forget to do the personal guarantees. They will just rent it out to this brand new business. And if the brand new business shuts down, then they don't really have any recourse there. That's one big mistake. I'd say being clear on who's responsible for the maintenance. A lot of them, especially if they're newer to like commercial real estate, they might kind of assume that it works just like residential, where they're responsible for fixing the plumbing and the toilet and the HVAC and stuff like that. But like, that's not necessarily the case for commercial. So if they're not experienced, they might be taking advantage that way. So those are two ways I can think of off the bat.
Okay, good. So we have a question from Facebook from Zach H. The question is, should a lessor ask for a phase one or two environmental study before entering a long-term lease?
Yeah, so that happens to that's in relation to the environmental laws under the federal environmental laws. Generally, you are strictly liable for the contaminants on your property, including
Hmm.
uh, so if you're purchasing commercial real estate or even if you're leasing it, you're strictly liable for any contaminants on the property, whether you put them there or not. But there is an exception. There's a safe harbor where if you exercise due diligence
Hmm.
and that due diligence shows that there was no contaminants, that there is no contaminants, then later on, if it's discovered that there were contaminants, then you're not responsible for them. So in order to do that due diligence, what's generally required is a phase one environmental study. Um,
Okay.
so it depends a little bit on the business and the context. If this is a large lease and a large rental, then I think it's worth getting, especially when you kind of have to consider like the history of the land. The phase one, my understanding is the phase one, they'll generally it's not invasive testing or anything like that. They're basically looking at the history of the property to see whether it's likely to have contaminants or not. Was the property ever a gas station? Things like that. If you're renting a office building in one of the big buildings in downtown Tampa,
Mhm.
then you probably don't need an environmental study. But if you're renting a warehouse, for example, then I do think I do recommend getting one in that situation, whether you're buying or leasing. And the leases generally will have environmental provisions in it that prevent the tenant from bringing any contaminants onto the property. Thank you, Zach.
William or Alvaro, I see Alvaro, do you have a question for?
No, I think that's
Okay.
been very helpful. I love the common area charges and I love the pass alongs, the triple net lease. I've seen these and and the personal guarantee. Although these are the core terms of the commercial lease. Thank you for the review and also the E2 sidecar.
Yeah, perfect. Thank you very much.
Yeah, especially for Famco, we have a lot of international investors, and they don't know. I mean, it's very different from France, so they don't know all that due diligence. And I always say to them, I'm not an attorney, I'm a broker, but if we have more questions, talk to an attorney, a real estate attorney, and make sure that everything is what you expected because they get some surprises. Yeah, yeah, yeah.
Right.
What is the biggest surprise you got, Felix?
Yeah, I kind of mentioned earlier where the person didn't realize that they were responsible for the roof, that it was.
Yeah, yeah, and I think it's common because I have another person, a member who was like not expecting the roof to repair the roof, and it
There you go.
was on the list.
Yeah.
Excuse
I
me.
William, do you have a question?
no,
Oh, bye-bye. Okay, Alvaro, do you have a question?
Comment. Well, first of all, thank you, Felix. Good conversation. The triple net, yeah, I was aware of that. That's a landlord something that one wants to aim for. But knowing that there's more than, like you said, more than just the rent, tax, and insurance, that's great, right? Something to have in mind. If one gets to the point that we can get a triple net. So thank you for that. The E2 visa that is new to me, so thank you for that as well. I was doing here some reading on my side on that. It says that it says that there's got to be a substantial investment, right, from the foreign person. It doesn't really specify what I can see, what a substantial investment is. So I don't know if you have more information on that. Um, yeah,
yeah, I mean, I'm not an expert in that area, but my understanding is that it has to be an active business. It can't just be like a passive. And generally, like rentals, for example, would be a passive investment. It has to be
Mhm.
an active
Active.
business. So actually operating and generally with employees and stuff like that. That's my
Yeah, you
understanding.
have to have a minimum, I think, of 2 or 3 employees, US employees.
they have to be U.S. employees, right?
Yes, correct.
Okay, and and they have to own. So in this investment, they need ownership on the business or property. Do you know?
They don't need to own the real estate, but they have to
No.
invest into business. So I believe they have to have ownership interest in the
Yeah,
in
so
the
you
company.
can or you can buy a business, existing business, or you can create a business. But then you have to have a list. Anyways, you have a business plan in place. You have a good immigration attorney to help you. And but you can do both. The easiest is to buy a business because you already have the business running and the employees. When you create a new business, it's different because I mean you don't have the revenue, the income. So you have to show, and you have to show that you're the professional as well. Like if you open a restaurant, you want to open a restaurant from scratch, you have to show that you have a background of hospitality.
Yeah, yeah,
Mhm.
and I mean, again, I know you guys maybe not the experts on this topic, but so this foreign person could be so getting paid, of course, from this business, but then so that allows them to get paid in US, like having open like a US account and getting the payments
Yeah. So,
distribution. Yeah.
so what I would suggest is just if you want, I can send you some immigration attorneys who can give you free consultation and talk to you more about it. Depends where the country where they come from as well. Yeah.
Yeah, that would be great. Thank you, guys.
Yeah, so you have Felix phone number, email, and Franco.org is the French American Business Council of West Florida. So we're here to help not only French, international. We do international as well. Okay. Any more
Thank you.
question, Alvaro?
That's all for now. Thank you, guys.
Well, thank you for being here. And thank you so much, Felix, because all this information I think will help everybody to see better. I remind you that this is recorded and the recording will be on our YouTube channel and on the website famco.org. So thank you again, Felix. Have a good day, good afternoon, and a good weekend.
Thank
Thank
you.
you.
Bye-bye.
Bye bye.